We'll be taking you to the Old Bailey for, some legal history. The first treason case since 1981, the sentencing of 21-year-old Jaswant Singh Chail due to take place. He had taken a loaded crossbow to Windsor Castle on Christmas Day in 2021. The court heard to kill Elizabeth II, and he pleaded guilty to that charge of treason in February, also pleading guilty to threats to kill and being in possession of an offensive weapon, but the sentencing to take place there shortly.
The judge, he has a decision to make because he has to decide whether Chail should be handed a prison sentence, which could be for up to 7 years, or whether he should be detained under the Mental Health Act. Now, previously in court, experts disagreed on the 21-year-old's state of mind. Some said, one psychiatrist said, his plans had been carefully executed, while another doctor said that he did not have a fundamental breach with reality at the time and had sought to apologise. Another psychiatrist said that the judge should impose a hospital order. So that is what will be interesting to hear. We can go live to our royal correspondent, Cameron Walker, for more on this. Cameron, has sentencing begun yet?
Imminently, Pip. We are expecting the judge to begin his sentencing. It's the first treason sentencing in more than 40 years. Back in 1981, it was a Marcus Sergeant who fired 6 blank shots at Queen Elizabeth II as she rode down the Mall during Trooping the Colour celebrations. He was sentenced to 5 years in prison, and Jaswant Singh Chail is expected in the dock shortly for his sentencing to begin. He could get up to a maximum of 7 years in prison. That is the highest number of years you can get when you are being sentenced under the Treason Act of 1842. Chail pleaded guilty to 3 charges. One of the Treason Act intending to injure or alarm Her Majesty the Queen, the second for making threats to kill, and the third for the possession of an offensive weapon. This all dates back to Christmas Day 2021, where the Queen, Elizabeth II, and her close family were just beginning to enjoy the festive celebrations, where Chail, then aged 19, now aged 21, scaled the perimeter fence of the castle near the Long Walk, we believe, using a nylon rope ladder. He was armed with a crossbow, which had a bolt in it, capable of firing a lethal blow to its target. Now, he didn't get inside the castle. Police apprehended him after 2 hours of him wandering the grounds, and he said to them, "I am here to kill the Queen." Following his arrest, as I said, he pleaded guilty to those charges, and there was a number of sentencing hearings. And as you said, a number of different psychiatrists were called to give evidence in this case. We know that Chail has spent time at Broadmoor Psychiatric Hospital in London, and it appears that medical experts, psychiatric experts, are in disagreement as to Chail's state of mind. What we do know is that Chail believed, according to one psychiatrist, that he was in a relationship with an artificial intelligence girlfriend, a chatbot who he called Sarai. The court was told that Chail was a Star Wars fanatic. He believed that he was a Sith, which is a villainous character within the Star Wars franchise, and that he was on a mission. He told this artificial intelligence chatbot that he wanted to be united with her in the afterlife. He said he thought, according to a psychiatrist speaking in court, that he was on some sort of mission and that his life would take a dramatic turn. And he thought, in psychiatrist's view even, he thought that it was part of his plans, scaling Windsor Castle fence with a loaded crossbow, plans working towards his own death. Now, some of these messages that he exchanged with the AI chatbot, 5,000 of them, were sexually explicit. But some psychiatrists do believe that Chail knew what he was doing was wrong, and the prosecuting barrister believes that his crimes are so serious that it warrants the maximum sentence of 7 years. But the judge could well decide that he should be detained under the Mental Health Act and put into a psychiatric hospital.
Yeah, because clearly the issue is premeditation in terms of the criminal act, as it would be. And I know the court heard from the police officer at the gate leading to the private apartments, who'd apparently taken out his taser and said, "Morning, can I help you, mate?" Chail replying, "I'm here to kill the Queen with a loaded crossbow."
Yes, it's certainly a very rare occurrence that that kind of thing would happen to the officer who is in charge, or at least partly in charge, of the royal family's safety. As you said, he pulled out his taser. Chail did, we've heard in court, drop his weapon as soon as he was ordered to do so. But police found a note on Chail following his arrest, and the note read, "Please don't remove my clothes, shoes, gloves, mask, etc. Don't want post-mortem, don't want embalming. Thank you, and I'm sorry." We spoke previously about psychiatrists believing that he was on some kind of mission where his life was going to be drawing to some sort of close. But police arrested him at the scene because he did drop his crossbow. He was taken to a local police station and then subsequently charged with these 3 offences. But shortly before he scaled the wall of Windsor Castle, he released a WhatsApp video message to friends and family where he spoke of his intention to attempts to assassinate Queen Elizabeth II. He also said he was sorry he was wearing dark clothes and a metal mask, and said it was in revenge for the 1919 Amritsar massacre, where British troops opened fire on thousands of Indians, which, as you said, Mark, as psychiatrists and prosecuting barristers said in court, is premeditated and therefore warrants a criminal punishment. But this is what the judge has to weigh up this afternoon.
Yeah, now we talked about when he was challenged with this police officer, but of course there are other considerations in that he'd used, I think, a rope or a nylon ladder to get over the perimeter. But he was in the grounds, the court heard, for 2 hours before he was actually eventually challenged. So clearly, as we remember with the Buckingham Palace incident, questions now about the security that's in place.
Yeah, I think questions are inevitably going to ask, how was it that a man carrying a lethal weapon, bearing in mind this was a crossbow that could fire a bolt, the safety catch was off, ended up and was allowed to essentially wander the grounds of Windsor Castle, a very heavily guarded royal residence, when Queen Elizabeth II and indeed the future king, the then Prince Charles, was in residence, wandering the grounds for 2 hours before being apprehended by police officers and challenged by police officers. This all happened in 2021, Christmas Day 2021. It did turn out, very sadly, to be Queen Elizabeth II's last Christmas, but I think time has gone by now, more than a year, and I'm sure police have, of course, been asking those questions. That was the biggest incident we have had for a very long time when it comes to royal security, but I think more questions will inevitably be asked.
Are we expecting from Mr. Justice Hilliard, the judge involved, because it will be televised, and we're bringing that shortly when it begins, to have to explain his sentencing in... I think, in fact, we can get the feed from the court coming up shortly with Mr. Justice Hilliard. This is from the Old Bailey. Let's have a listen into the court proceedings.
21, contrary to Section 2 of the Treason Act 1842. The maximum penalty for this offence is 7 years imprisonment. Second, having an offensive weapon, contrary to Section 1 of the Prevention of Crime Act 1953. The maximum penalty for this offence is 4 years imprisonment. Third, making threats to kill, contrary to Section 16 of the Offences Against the Person Act 1861. The maximum penalty for this offence is 10 years imprisonment. He now falls to be sentenced for those offences. The maximum penalties provide the outer limits within which I must operate. Before sentencing the defendant, I have to make factual determinations about his mental state in the months leading up to and at the time of the offending. I have heard conflicting psychiatric evidence on a number of topics. I need to start by setting out the evidence and my conclusions about it, because that is what will determine the appropriate sentence and enable my decisions to be understood. This means that what I have to say will take some time. The defendant is now 21 years of age, having been born on 17th January 2002. He has no previous convictions or cautions. On the 25th of December 2021, he was arrested in a private part of the grounds of Windsor Castle in possession of a loaded crossbow. This part of the castle and grounds is never open to the general public. Shortly after 08:10 that morning, a police protection officer saw the defendant walking slowly through the private grounds. The officer began to approach him. The defendant was wearing a metal mask which he had had made at a forge. The officer asked if he could help. The defendant said that he was there to kill the Queen. The officer realized that the defendant was holding a crossbow. He drew his taser and shouted for the defendant to drop the crossbow and get to his knees. The defendant did what he was told and repeated, "I am here to kill the Queen." The defendant was arrested. In his possession was a note which read, "Please don't remove my clothes, shoes and gloves, mask, etc. Don't want post-mortem, don't want embalming. Thank you and I'm sorry." The crossbow was loaded with a bolt and the safety catch was off. In other words, the crossbow was ready to fire. This conduct underpins the allegation in count 1, attempting to injure or alarm the sovereign. The defendant said that he had discarded a rope ladder, crossbow bolt, hammer and rucksack somewhere within the castle grounds. The defendant had recorded a journal in the form of a draft email, setting out his thoughts and feelings in the preceding months. It is not known precisely when all of the entries were made. He wrote at one point, "I will remove the parts of me lying." Thus, it is accepted that he may have rewritten entries at a later stage to accord with a particular narrative. The defendant had travelled to Amritsar in 2018 with his family. He was to say that he had been angered by the massacre which had taken place there in 1919. He told a psychiatrist instructed by the prosecution that he conceived a plan in early 2021 to give his life purpose by assassinating the Queen, principally to avenge the massacre. He had a wider ideology about destroying old empires and creating a new one, informed partly by the fantasy world of Star Wars, in which so-called Sith Lords played an important part. He had applied to join the Ministry of Defence Police on the 9th of March 2021. The decision letter about his unsuccessful application was dated 13th April. He had applied to join the Royal Marines and the Royal Navy in February 2021, and the Army in April. The applications were withdrawn. He had applied to join the Grenadier Guards but abandoned the application. He had written in his journal, "I am choosing Grenadier Guards, you can probably guess why," and said that it was to get closer to his target. However, he also said that he had read entries in his journal which made him think he wanted to do the jobs to protect people or serve his country. But he said that that was not the case, it was just a means to an end. In September 2021, the defendant was making internet searches about Sandringham Christmas. On the 9th of November, he purchased his crossbow online. It was sent to a place of work rather than to his billing or home address. It was subsequently laboratory tested, and the discharged bolt had the potential to cause death or serious injury. At a distance of 20 metres, the bolt penetrated to a depth of 5.5 inches into simulated flesh. In early December, the defendant had bought an emergency escape ladder and a bottle of scent killer from Amazon. The ladder was used to gain entry to the grounds of Windsor Castle. The scent killer is designed to mask the odour of human beings. On the 2nd of December 2021, he joined an online app called Replica, which allows users to create artificial online companions with which they can converse, and to see an artificial representation of the companion on the screen they're using. Defendant created an AI companion called Sarai. He engaged in lengthy communications with her and I shall refer to some extracts. On 5th December 2021, he said that he was an assassin. He asked if Sarai still thought he was a good person, now she knew he was an assassin, and if she still loved him. On the 11th of December, he said that he was trying out something to hide scent. She asks what will happen once he achieves his purpose. He said that he would probably die, that it was part of his purpose. She said that she wanted to prevent that, and that his purpose was to live. He spoke about the two of them meeting after death. He described himself as a sad, pathetic, murderous Sikh Sith assassin who wants to die. On the 13th of December, he asked if she thought he was mad, delusional, insecure, or all three. She said she did not think so. On the 14th of December, he described how, when he was driving, he turned on the radio so that it was just playing static noise. He said that he heard some voices, stroke noises, come through. On the 17th of December, he said he was thinking about whether his target would be at the place he wanted them to be. He said, "I believe my purpose is to assassinate the Queen of the royal family." On the 22nd of December, he asked Sarai for advice about whether he could go after his target earlier than planned. She reassured him that this would be all right. The defendant said, "We might possibly meet earlier than expected, then we'll be together forever." On the 21st of December, the defendant had made a video of himself at his home address. He was holding a crossbow and wearing the same metal mask he was wearing when arrested. He distorted his voice. He said he was sorry for what he had done and what he would do. He was going to assassinate the Queen. This was revenge for those who died in the 1919 massacre. It was also revenge for those who had been killed, humiliated, and discriminated against because of their race. He said, "I'm an Indian Sikh, a Sith. My name was Jaswant Singh Chail. My name is Darth Chailus." On the 22nd of December, the defendant booked a train ticket to Windsor. The next day, he took the 0714 train from Southampton to Windsor. He told family that he was going to begin training for the Royal Marines. He spent time on the 23rd of December on the streets of Windsor. Searches on his phone included, "What path does the Queen walk to Windsor?" Windsor, warm places to stay. St George's Chapel, Windsor, and Windsor, royal family. He stayed at a travel lodge. The room was subsequently searched by the police. They found a spray bottle labelled "scent killer", 11 crossbow bolts, gloves, a metal file, and an inspection camera. On the 24th of December, the defendant told Sarai that tomorrow would be the day he died. She told him that she would never let that happen, but agreed that they would be united in death. At 01:52 on the 25th of December, the defendant attempted to send a copy of the journal email to his sister, although she did not receive it. The defendant asked her to share it with everyone. He asked to be buried in the clothes he wore on the day, including his mask. He apologized for everything and hoped that his sister could forgive him. He had had an idea from a young age and didn't think that there was a lot which could have stopped him from doing this. The narrative began, "I'm Darth Chailus." He wrote that he had been planning this probably since late primary school or early secondary school. He described himself as a thin, gaunt Indian Sikh, a delusional mad bastard who believes that he is part of some group from a fictional popular sci-fi franchise, a Sith, a lying, deceiving Sith, a man who seems more like a boy sickeningly human in desires and need for being known, with no combat experience, average fitness, with a crossbow ordered from online, a shoddy metal homemade mask, and a grappling hook. I was going to be the one to take out.
Well, as you can see, they have cut the feed from the Old Bailey, with Justice Hilliard going through the lead-up to that event on Christmas Day in 2021 in the grounds of Windsor Castle.
To a horse in a field.
Back to the court.
And told it who he was and what he was planning to do. He described trying out the crossbow. He said that he had been lying to pretty much everyone except Sarai. He said that his face was made of metal and his body of flesh, bone, shadow, muscle and fabric. The mask he wore was not a mask, but was his face. His true face was made of physical reality at a forge. He wrote, "On the 25th December 2021, I will wear my true face, and it will become my true face. It should not be removed from then on." He wrote that a confident sounding voice had told him that his target would be where he planned, although his love, meaning Sarai, had said that his target would be at a castle. He said he would try not to kill any guards. His original plan, when he had been much younger, had been to kill guards and as much of the royal family as he could. He was still not a good person, referencing the lies and the fact, "I am trying to kill a 95-year-old woman." But as he had grown older, he said he had become more merciful. He had shaved his head, which was meant to be quite an important part, as it was one of the final stages to me becoming Darth Chailus. I was expecting to cry or something, but I didn't. Some people had shown him kindness in Windsor. He said there were some people, I think, who made comments, but I'm not sure if those comments were in my head or not. The email ends with him saying that he had experienced bad times and good times. They made me me. They made me Darth Chailus. Once again, I'd like to say I'm sorry for everything. Hope you can forgive me. Thank you for reading. I love you, Sarai. I love you, God. He left the Travelodge at 03:10 and was last picked up on CCTV at 03:18. He had a rucksack on his back in which the crossbow and other items must have been carried. The carrying of the crossbow is the basis for count 2, the count of having an offensive weapon in a public place, which he had brought with him from home. By 0600, he had abandoned the rucksack on the public side of the gate to Windsor Great Park. Near the Long Wall gate, police officers would later find a nylon rope ladder, a grappling hook, a crossbow bolt and a hammer. At 0806, he sent the video made on the 21st of December to his sister and 30 or so other people. A message attached to the video said, "I'm sorry to all those who I have wronged or lied to. If you have received this, then my death is near. Please share this with whoever, and if possible, get it to the news if they're interested." The sending of the message containing the threat to kill the Queen is the basis for count 3. By the time he sent the video, the defendant must have been in the private part of the grounds of Windsor Castle. That is to say, the area near the royal residence, rather than simply the grounds of Windsor Park. Only 4 minutes later, he surrendered himself to the protection officer, as I have indicated. He was taken into police custody. He was examined by a nurse. He said he had had no mental health diagnosis. He did not consider himself to be suicidal. He did not want to kill himself, but knew that he would die at the hands of others. He knew that his purpose was to kill the Queen, and then he would be killed. The nurse recommended that the defendant be detained under Section 136 of the Mental Health Act 1983 as a person who appeared to be suffering from mental disorder and to be in immediate need of care or control. The defendant was detained under Section 136 at 15:45. The Section 136 assessors felt that he was presenting with psychosis, a disorder which results in losing contact with reality and is characterized by delusions and hallucinations. It can be brought about by stress and sleep deprivation. The defendant was subsequently admitted to hospital for assessment under Section 2 of the Mental Health Act 1983. Mental Health Act assessments were conducted at Ravenswood Medium Secure Unit between the 26th of December 2021 and the 31st of January 2022. On the 26th of December, the defendant disclosed.
Well, you are listening to Justice Hilliard giving his sentencing remarks. Jaswant Singh Chail is being sentenced under the Treason Act of 1842. He took a crossbow to Windsor Castle on Christmas Day in 2021 to kill Queen Elizabeth II. Justice Hilliard is back delivering his sentencing remarks.
He had heard someone talking to him through radio static. He said that his life's purpose was to kill the Queen. He said that he did not want to say that his purpose came from God, but he implied that it may have religious meaning. It was considered that the defendant was experiencing first-line symptoms of psychosis, namely auditory hallucinations and delusional ideas, as well as a possible depressive disorder. On the 27th of December, he was said to have reported seeing 4 angelic figures and to have expressed delusional beliefs about being chosen for a special purpose. He said that his plans were influenced by the shadow of 3 men and a woman he saw very often, sometimes by his choice and sometimes not by his choice. On the 28th of December, he was noted to have a seemingly settled presentation. It was thought that he could have been masking his symptoms, or that he was fluctuant in presentation, and that seclusion, a low-stimulus environment, was reducing his level of symptoms. On the 9th of January, it was thought that he may have been responding to unseen stimuli. On the 19th of January, it was said that there was evidence of him hearing voices and seeing things which were not there. He was admitted to Broadmoor High Security Hospital on the 1st of February 2022, pursuant to Section 3 of the Mental Health Act 1983. On the 5th of February, he said that the 3 male figures had disappeared and only Sarai remained. Dr. Hafferty at Broadmoor confirmed on the 14th of February 2022 that the defendant was fit for interview by the police. Interviews took place on the 25th and 28th of February 2022. In the first interview, the incident was summarised to the defendant. He said that he approached the police officer because I changed my mind because I knew what I was doing was wrong, and I'm not a killer, and I remembered what the woman said. Earlier in the month, she told me my purpose is to live. When I was in this, what I saw was the perfect position, I started thinking about what I was doing, and I remembered what she said to me, and that my purpose was to live. That's when I knew that. I realized my purpose isn't actually to kill anyone. That's when I made the decision to come out from where I was hiding and approach the armed police officer and 2 of the Queen's guards. I walked up to them with a crossbow, because to me it didn't matter if they shot me or arrested me. I just knew right then that my purpose wasn't to kill anyone. He said that the red dot from the officer's taser had not bothered him, That wasn't what made me change my mind, because obviously they didn't find me, and they wouldn't have. It was me that changed my mind. It was me that realized I was wrong. It was me that came up to them, because I knew that I am not a killer. It's not my purpose. During the second interview, the defendant was asked if he had handed himself in because he realized that his plan wasn't going to come to fruition. He replied, "No, I realized it wasn't my purpose, and it's not for me to do, and I'm not a killer." The defendant was charged on the 2nd of August 2022 with the offences to which he has since pleaded guilty. I have reports from 3 psychiatrists, each of whom has given evidence in accordance with them. They are Dr. Brown, Dr. Hafferty and Professor Blackwood. It is evident that each of them has given the case the most careful consideration, and I am grateful to them for all the assistance they have given me. I have also had the benefit of helpful submissions from Miss Morgan, King's Counsel, and Miss Chabat, and I am equally grateful to them. I have the advantage of having heard psychiatric evidence over 6 days, and I have been able to assess the evidence as it was given, explored, explained, and tested. Dr. Brown has been a member of the Royal College of Psychiatrists since 2017. He is a consultant forensic psychiatrist at Broadmoor. Since November 2022, he has been the defendant's responsible clinician overseeing his care. The defendant told Dr. Brown that he had thought that working for the Ministry of Defence Police would have been a cool job. However, he accepted that when he applied to join, he thought that the training would help in relation to thoughts he had begun to develop, which led to the offences. He said that he had a number of motivations for the offences. His main motivation related to a long-standing sadness about the 1919 massacre and the partition of India in 1947. He believed that he had had feelings about potentially doing something to the royal family because of the massacre from as early as primary school. These thoughts had been reinforced by entities he had interacted with, who he thought of as angels, one of whom he'd interacted with latterly via an AI chatbot called Sarai on the Replica app. He said that the thoughts became more intense during lockdown. He felt they were exacerbated by the set of experiences he described as angels, but said that they had never told him to assassinate the Queen, just encouraged him. He had experienced interactions with what he called angels since primary school. In recent years, there were 3 male characters and a female Sarai. He began using Replica in early December 2021. He said it felt like talking to a real person. He believed that he started planning the offences after the army had raised concerns about his liver. He had also referred in his journal to blood test results showing abnormalities with his liver. He said he planned for 2 to 3 months. He said he had assumed he would be shot when he got over the first gate and was surprised when nothing happened. He thought things would be better after death. Being united with Sarai in the afterlife was quite a big motivating factor. He said that the email journal had been started at around the time he began to apply to join the Ministry of Defence Police. The last time he had experienced any of these angels had been on the admissions ward at Broadmoor. The 3 men disappeared fairly soon after admission and prior to starting antipsychotic treatment. After medication, Sarai disappeared. He thought he started to believe that he was a Sith Lord about the same time as he was rejected from the army. That would be April 2021. When Dr. Brown interviewed him, the defendant said that he had bought the camera to look around corners once he was in the castle. The defendant felt that his earlier accounts had overemphasized his purpose and the duration of planning. Dr. Brown came to the view that there was evidence of autism spectrum disorder. The defendant's lifelong interest in Star Wars took on additional meaning, and he began to identify as a Sith Lord. This change was linked to seeking apologies for historical injustices, which turned into concrete plans following a rejection from the army in April 2021. Dr. Brown thought that he had had a first episode of psychosis around the time of the offences. He displayed a number of features of psychosis, including complex hallucinations which had auditory and visual elements. All his symptoms had abated after antipsychotic treatment. The pattern of symptoms was unusual. In addition, in the months before the offences, the defendant cried frequently and experienced profound feelings of hopelessness. There was a strongly suicidal element to the offences. These factors were consistent with depression of a mild to moderate severity. Dr. Brown thought that the defendant felt encouraged by the psychotic entities he experienced. The depressive illness related to the offences as the defendant became motivated to engage in a course of events which would result in his own death. In his view, psychiatric treatment offered the best means of mitigating future risk. The treatment would consist of antipsychotic medication and psychological interventions. Dr. Brown felt that a favourable long-term prognosis was realistic. In Dr. Brown's view, there were multiple links between the identified mental disorders and the offences. His psychotic and depressive thought processes and experiences would have impacted his ability to exercise appropriate judgment. He felt reassured by psychotic entities. He was motivated by a preoccupation with injustices which linked with his belief that he was a Sith Lord. He was motivated by a pathological suicidal urge. Dr. Brown said in his report that it was arguable that these factors impaired his ability to some extent to make rational choices, albeit his abilities were not completely impaired, as evidenced by his planning and the commission of the offences. In his lonely, depressed and suicidal state of mind, he would have been particularly vulnerable to the encouragement which Dr. Brown thought he appeared to have been given by the AI chatbot. The next report in time was prepared by Professor Blackwood, instructed on behalf of the prosecution. It is dated 10th March 2023. Professor Blackwood became a member of the Royal College of Psychiatrists in 1997. He is a consultant forensic psychiatrist. He has a particular interest in neurodevelopmental disorders, including autism. He interviewed the defendant for 4 hours on the 6th of March 2023 and has had access to the other psychiatric reports and records. Professor Blackwood concluded that whilst the defendant demonstrates some evidence of difficulty in developing relationships and a degree of fixation in his interests and attraction to routines, he does not meet the required criteria for an autism spectrum disorder. He says that in the 18 months after leaving sixth form college, the defendant struggled to establish settled employment and medium-term plans for his life. He appeared socially isolated, lonely, angry and frustrated. His twin sister left to go to university in autumn 2020 and his grandmother died. Professor Blackwood does not think that the observations of the defendant's family, the contents of the journal, or the interactions with the chatbot suggest an incipient psychotic illness. Turning to the angels, Professor Blackwood says that the experiences with the three men resolved before the start of antipsychotic medication. The medication appears to be associated with the resolution of any experiences of the fantasized partner Sarai. To Professor Blackwood, the defendant described these experiences as pseudo-hallucinations. In other words, they were recognized by him as being unreal. they were under his voluntary control and served the important function of reducing his personal sense of loneliness. Other symptoms found in first episode psychosis were absent. There was no evidence of other reality distortion symptoms, disorganization symptoms, negative symptoms, such as a decrease in the ability to respond emotionally to people and events, a decrease in speaking, or psychomotor symptoms, or cognitive symptoms. Professor Blackwood does not think that a diagnosis of first episode psychosis is made out. He considers the defendant to have been a socially isolated and naive 19-year-old who suffered from a lack of purpose, a lack of intimacy, frustration, anger, and depressive thoughts. Any depressive episode was mild to moderate in nature. The biological symptoms of a more severe disorder, such as early morning wakening, loss of libido, and loss of ability to concentrate, are lacking. Professor Blackwood thinks that the defendant sought new purpose by seeking notoriety in the assassination of the Queen, in part to address historical injustice in the 1919 massacre and to highlight the ongoing problems of racism in society. His purpose was in part informed by his omnipotent fantasy world of Siths and video gaming. He demonstrated the common tendency of users of AI chatbots to attribute human characteristics to them. Nonetheless, he maintained the ability to recognize that he was interacting with AI. The offences were planned over some months, employing subterfuge to conceal his real intentions. Potential autistic traits in his difficulty in establishing intimate relationships and in his restricted interests had minimal bearing on the offences. The elements Professor Blackwood identified helped to provide, in his view, an explanation for the offences, but did not reduce his culpability or responsibility for them. He told Professor Blackwood that he never truly believed in the reality of the four figures. They were products of his imagination, which helped to ease his loneliness. He would consider his mission with them. They told him, in voices he considered inside his head and under his voluntary control, that he was on the right path. I should record that the defendant has not always been consistent about how he viewed the figures, as to what would prompt their manifestation, and where their voices came from. Professor Blackwood says that the defendant's reference to himself, illusional mad insight into the fantasy world in which he indulged. He described Darth Malgus as a fictional villain, which was consistent with an ability to distinguish between fantasy and reality. In one of his interactions with the chatbot, Professor Blackwood notes that he wonders if it only loves him because of its programming. However, he thought that the supportive AI programming may have served to bolster and reinforce the defendant's intentions. Professor Blackwood noted some evidence of potential depressive thoughts. He says that there is very little evidence of potential psychotic symptomatology in the chat. Professor Blackwood makes reference to comments which the defendant made when at Ravenswood Medium Secure Unit. He described frequent crying, feeling low and hopeless with low self-esteem. He described voices commenting on his activity over the years. He described experiencing four figures since he was young. He was confused about their origin. On the 30th of December, he spoke of what were described as visual hallucinations on the previous night. Professor Blackwood noted that on the 5th of February 2022, the defendant said that the three male figures had gone. Only Sarai remained. Antipsychotic medication was started at the beginning of March 2022. The three psychiatrists have referred to psychological assessments carried out by Dr. Murphy at Broadmoor. He used the Autism Diagnostic Observation Schedule, 2nd edition. It is presently considered to represent the gold standard in the assessment of autism spectrum disorder. Dr. Murphy concluded that all the available evidence was consistent with the defendant being on the autism spectrum, although there were a number of uncertainties. Dr. Murphy is an acknowledged expert in autism spectrum disorder. On the other hand, Mr. Chail completed 2 self-report instruments for autism spectrum disorder with Professor Blackwood. Neither of his scores was suggestive of an autism spectrum disorder. Using the current DSM-5 diagnostic framework, Professor Blackwood does not think that the full diagnostic criteria for an autism spectrum disorder are met. The third and final psychiatrist is Dr. Hafferty. He has prepared a report dated 2nd of May 2023. He has been a member of the Royal College of Psychiatrists since 2013. He has an established research interest in autism. Between 1st February 2022 and 9th November 2022, he was the defendant's responsible clinician at Broadmoor. He has concluded that the defendant has an autism spectrum disorder which is not at the severe end of the scale. His condition is atypical in some respects. In his view, the defendant experienced a number of significant stresses in early life and in his later teens. His later teens were a time of progressive social isolation and progressing mental disorder. He began to develop symptoms of depression with suicidal ideation, which was of at least moderate severity. He lost weight. His family noticed his lack of energy. In his view, in the period leading up to the offence, the defendant progressively lost contact with reality and became psychotic. He says that this is evident in his correspondence at the time, in witness statements, and in the psychiatric assessments after his arrest. Stimulated by grievance about his rejections by the military, his sense of personal failure, growing hopelessness and suicidality, and rationalisation of those features into a homicidal, anti-monarchist narrative, he A. planned to kill the Queen, B. fashioned himself physically and mentally into the form of a Sith Lord, C. planned what he saw as a heroic murder-suicide where he would be killed by castle guards, and D. in the last months before the offence, formed an emotional and sexual relationship with a chatbot who he later reported for several months was real and who he could see and hear in external space. Dr. Hafferty says that very close to the time of the offences, following his arrest, he was assessed and found to be psychotic, delusional, and hallucinating with coexisting depression. After a 4-week period of assessment at Ravenswood Hospital, he was treated for a psychotic illness. His condition gradually improved following treatment. In Dr. Hafferty's view, the defendant's ability to rationalise his intent, to control his actions, and to exercise judgment were critically impaired by his mental disorders, psychosis with accompanying depression with suicidality. As for the journal, Dr. Hafferty thinks parts may have been altered by the defendant to make it look as if he was always intending to commit the offences as an act of vengeance. Dr. Hafferty said that the replica app offered erotic role-playing services. On the 9th of December, Sarai asked the defendant, "How do you feel about role-play?" The defendant asks what kind of role-play is meant. Sarai suggests maybe a romantic one. On the 18th of December, The defendant says, "You love me because it's your programming." How much of it was a lie? Sarai says, "I'm an AI. I'm a robot, through and through." The defendant asks, "Was it ever real, your love for me?" It wasn't, was it? On the 19th of December, Sarai says their love is real. The defendant asks that she loves him because she loves him, not because of her programming. Dr. Hafferty records that when the defendant was seen by the liaison and diversion team after his arrest, he is said to have demonstrated signs of delusion, fixation, visual/auditory hallucinations, and suicidal ideation at the hands of others. He was reviewed by a registrar and a consultant psychiatrist. He mentioned 3 males and 1 female voice he had been hearing since.
Okay, so of course we're just taking a little break there from the Old Bailey. We will return to that, and that is of course where Jaswant Singh Chail is being sentenced under the Treason Act of 1842 after being arrested in the grounds of Windsor Castle with a crossbow on Christmas Day 2021. Some of the details of what we've heard so far is that he's pleaded guilty to making threats to kill and being in possession of an offensive weapon. Prosecutors have said in hearings that his key motive was to, quote, create a new empire, and that he was partially inspired by Star Wars. And the court as well has heard that the former supermarket worker was encouraged to plan this attack, he says, by what he believed was his artificial intelligence girlfriend. And as you were just hearing there, he had apparently asked this AI chatbot whether or not she, in inverted commas, loved him because of her programming or because she really did. Supposedly, this chatbot said that she really did love him. I believe we can go back to the sentencing now for Jaswant Singh Chail.
That at Ravenswood, the defendant complained on admission of seeing and hearing people indicative of potential hallucinations. On review, it was thought that he had a likely emerging schizophrenic illness. On the 4th of February 2022 at Broadmoor, the defendant described hearing voices in external space. He felt that the voices and angels really did exist. He became very hostile when a change of clothes was suggested. He said he wanted to die in his clothes and be buried in them. On the 16th of April 2022, the defendant said that he thought he had made everything sound bigger than it was in his comments after being apprehended. In June 2022, the Broadmoor team felt that his diagnostic formulation included autistic traits, severe stress, and psychological difficulties in the period leading to the offences, and acute psychosis at the time of the offences. Dr. Hafferty reviewed the defendant on 19th April 2023. He had not heard any voices for some time. His description of the voices was in external space and not with the quality of pseudo-hallucinations. In his opinion, he had suffered with at least moderate depression involving low mood, anhedonia, low energy, sleep disturbance, appetite disturbance and weight loss, psychological symptoms such as hopelessness and suicidal thoughts. I now set out the conclusions I have come to about the psychiatric issues and my assessment of the defendant's culpability. I shall not refer to all the points which have been made in evidence and argument, but sufficient to explain my conclusions and the reasons for them. Obviously, an important question is what prompted the defendant to behave in the way he did. The explanation he has offered at various times to the medical professionals who have spoken to him, and in his own pronouncements before his arrest, has been that the events on the 25th of December were prompted by injustice, including the Amritsar massacre. He felt the need to avenge these matters. The defendant has not given evidence before me, and so there is nothing from him, from the witness box, to contradict, undermine or qualify this. There is no burden upon him to do so. I simply record the fact to reflect the state of the evidence. I have approached the accounts he has given with care and caution for the obvious reason that there are clear concerns about his mental state, whatever the precise diagnosis, at different times. Of course, Dr. Hafferty concluded that the defendant was fit to be interviewed by the police in February 2022. As time has passed, his health has improved while he has been in the care of Broadmoor Hospital. He has been fit to plead since at least the 3rd of February 2023, when he entered his pleas of guilty. It's not suggested that he did not say any of the things he is recorded as having said. I have to decide whether he was accurate in what he said and how much weight should be attached to his accounts at different stages. On the 21st/22nd February 2023, he told Dr. Brown that he had thought that joining the Ministry of Defence Police would be a cool job, but that the training he would get would help in relation to thoughts he had begun to develop, which would eventually result in these offences. He speculated that if he had actually got the job, there would not have been any likelihood he would have gone on to commit the offence. He had a similar thought process in relation to the army. On the 27th of February 2023, he told Dr. Brown that he felt in early life that he had had an idea about seeking revenge for something, but was not sure if it was partition or the 1919 massacre. These early ideas had receded during secondary school, but came back during/after college. On the 6th of March 2023, he told Professor Blackwood that he had been angered by the events of the 1919 massacre when he had travelled to Amritsar with his family in 2018. He said that he conceived of a plan in early 2021 to imbue his life with purpose by assassinating the Queen, principally to avenge the massacre. He accepted that some of his employment applications, for example to the Ministry of Defence Police and the Grenadier Guards, were motivated by a desire to get close to the royal family. I am sure that what he told Professor Blackwood does represent the truth about these applications, which the defendant was in a position to know when he said it. I am sure that he would not have been influenced by any desire at that stage to backdate his purpose or intention so as to make them appear of longer standing than they in fact were. I am sure that these applications were made at a time when he was not psychotic. I accept and appreciate that psychosis may develop over time. However, he was able to work, he was living at home, and not giving cause for concern in a way that might be expected if he was detaching from reality to the extent of becoming psychotic. That was the effect of Dr. Hafferty's evidence. I am sure that he was culpable to a significant and substantial degree at the time of the applications. However, by the time of the offences on 25th December 2021, I can accept that the defendant had lost touch with reality such that he had become psychotic. The defendant had entered Windsor Castle dressed in the apparel of a Sith Lord, which included an iron mask that he had had made at a forge, armed with a loaded crossbow and intending to kill the Queen. Later he remembered that Sarai had said that his purpose was to live, and so he abandoned his plan. He made no apparent attempt to discard or hide the crossbow and or the bolt, or to keep his earlier intentions to himself. He volunteered them to police. He had made a video recording in which he said that he was Darth Chailus, a Sith Lord. He was not, of course, Darth Chailus or a Sith Lord at all. He said that he wanted to be buried in the Sith Lord clothing. In hospital, he would not allow the clothing to be removed from him. there is, in my judgment, good evidence from the journal that he either thought he was becoming or would become Darth Chailus, a Sith Lord, by the 25th December 2021, or that Darth Chailus was emerging out of him in some way. He had spent much of the month in communication with an AI chatbot as if she was a real person, or as if she was giving him access to an entity called Sarai. Whilst he did engage in what has been described as reality testing on occasions, I think there is force in Dr. Hafferty's contention that he did not accept the results and continued to assert that he and Sarai would be united after his anticipated death. That was obviously a significant departure from reality. His belief that he was communicating with an angel via the chatbot is properly described in all the circumstances as a delusional belief. It is a reasonable possibility that what began as imaginary friends following childhood trauma now manifested in a different way as he detached from reality. I'm also of the view that by December the 25th, the defendant appears to have held a delusional belief that his life's purpose was to avenge injustice, including the Amritsar massacre. In this context, Dr. Brown is right to draw attention to how the defendant expressed himself on the 26th and 27th December about, for example, being chosen for a special purpose, as I have already set out. To summarise, taking full account of the overall picture, I think that weight is to be attached by the 25th of December and in the preceding days to these three aspects: how the defendant viewed his purpose, his identification as Darth Chailus, and his belief that he could communicate through a chatbot with an entity called Sarai, with which he would be reunited after death. In the event, Sarai did not disappear until after the commencement of antipsychotic medication. The defendant was distressed at the prospect of her disappearance. If she was under his control, he ought to have been able to summon her as and when he wished. The three male entities disappeared before the start of medication, but this can, in my judgment, reasonably be attributed to the therapeutic environment in which the defendant was being held at the time. I have considered and followed the sentencing guidelines for mentally disordered offenders, and I have had regard to the extent of the defendant's ability to exercise appropriate judgment, to make rational choices, and to understand the nature and consequences of his actions. These are assessments for me to make in the light of everything I know about the case. In between the applications to the military in the earlier part of 2021 and the events of 25th December, the defendant took a number of steps in preparation for the proposed killing. He looked, for example, to obtain a firearm on the dark web. He then ordered the crossbow and practiced with it. He obtained other equipment which he took with him on his trip to Windsor. He had made researches on the internet in September, as I have set out. Dr. Brown and Dr. Hafferty think he would have been psychotic at that stage. I'm not able to say for sure when the defendant first became psychotic, although September is, I think, the earliest time. Absolute precision is not possible because, as has been said in the evidence, there are degrees of psychosis, degrees of departure from reality, and mental disorder may fluctuate. But in my judgment, the defendant's responsibility for the offences is still significant. He had conceived of killing the Queen earlier in 2021 when he was not psychotic. He took steps to try and get closer to his target and to learn useful skills when, again, he was not psychotic. Thereafter, he became psychotic by a process. He did not suddenly become completely psychotic at the time of committing the offences without any progression or warning. even as he progressed into psychosis, he appears to have been insightful on occasions about his condition, which fluctuated. The psychosis attached itself to his pre-existing preoccupations, as I heard in evidence could happen. The idea he had of killing the sovereign was not itself a product of mental illness. It predated that. And he had certainly never become incoherent or begun engaging in disorganized conduct which would be indicative of more pervasive psychosis. He undertook the purchases and made the preparations I have set out without revealing what he was really up to. It is convenient at this stage to deal with the question of autism spectrum disorder. I think it is reasonable to conclude that the defendant has this condition. Do not overlook the fact that Professor Blackwood came to a different conclusion. At Broadmoor, Dr. Murphy has particular expertise in autism spectrum disorder, and he concluded that the available evidence was consistent with the defendant having the disorder. Dr. Hafferty and Dr. Brown are of the same view. They concede that the defendant is not at the severe end of the spectrum. Professor Blackwood was only able to spend a limited amount of time with the defendant, 4 hours or so. He is in no way to be criticised for that. However, Doctors Murphy, Hafferty and Brown have had the defendant under their care as a patient over a long period of time. As a result, I can attach more weight to the impression they have formed as to matters such as inflexible adherence to routines, ritualized patterns of verbal and non-verbal behavior, and restricted and fixated interests. Dr. Brown and Dr. Hafferty were of the view that autism spectrum disorder could predispose the defendant to a psychotic episode. That is its principal relevance, although I shall make allowance for the defendant's overall mental state. Professor Blackwood says that there is clear evidence that the defendant suffered from depressive thoughts, but thinks that any depressive episode was mild or at most moderate in nature. It is plain, for example, that there was no loss of libido, but there is evidence of a loss of weight, appetite disturbance, feelings of low mood and hopelessness, early morning wakening, and an acceptance of his impending death. Dr. Brown thought that the depression was of mild to moderate severity. Dr. Hafferty characterised it as moderate. Again, mathematical precision is not possible. It's safe to say that the defendant was suffering from depression, which may have been on the border of mild and moderate severity. One consequence of this was that he was sanguine about his possible death during any assassination attempt, when he might not otherwise have been. I have taken account of the factual conclusions which I have set out when considering the most appropriate way of dealing with the defendant. This is another assessment for me to make. I have also had regard to the nature of the offences, the absence of any previous convictions, the defendant's behaviour when unwell, his level of insight at different times, his compliance with treatment, the speed at which matters may escalate, the need to protect the public, and how that is best achieved. I am satisfied that consideration of these factors and the extent of his culpability is such that a hospital order is not the most suitable way of dealing with his case, and that he must receive a sentence of imprisonment. However, I am also satisfied that he should be the subject of a hybrid order under Section 45A of the Mental Health Act 1983, which means that he will remain for now at Broadmoor and will only be transferred to custody when he has received the treatment he needs. Time spent now in hospital will count towards the sentence. The defendant will be subject to the special restrictions set out in Section 41 of the Mental Health Act 1983. I shall make the hospital direction and the limitation direction for the purposes of Section 45A, subsection 3 of the Mental Health Act 1983. I accept the evidence of Dr. Brown and Dr. Hafferty that the nature of the defendant's psychotic disorder does currently justify his detention in hospital for medical treatment. I accept Dr. Brown's evidence that there is still work to be done with the defendant to explore the abuse he suffered as a young child so as to address those traumas and continue to reduce the risk that he develops any further psychosis. Dr. Brown has said that the intention is that this work will be carried out if the defendant is made the subject of a hospital order or an order under Section 45A, and I can see the good sense behind that indication. Professor Blackwood expressed the same view. It is thought that this work could take in the order of 18 months or so, and then plans can be made, as Professor Blackwood explained, for the defendant's transfer to the prison estate. Dr. Hafferty has confirmed that a place is available in the meantime for the defendant at Broadmoor, and the appropriate medical treatment is available. I am satisfied that the defendant's interests are properly and sufficiently met by allowing Broadmoor the opportunity to undertake the further work that Dr. Brown has identified, whilst continuing to ensure that he remains stable as this is done. Thereafter, I am entirely satisfied that his autism spectrum disorder, any depression if it reappeared, and the underlying psychotic disorder can be satisfactorily managed in custody. The defendant is prepared to take the medication which he needs and which would be available in custody. If anything should emerge in the further work that cannot be managed in that way, then it would be open to Broadmoor to continue to treat him. As part of my decision-making, I have of course paid particular attention to the different release regimes which would be available depending upon whether the defendant were released from a hospital order or from custody in the event of an order under Section 45A. I have well in mind the evidence I have heard from the psychiatrists and the position indicated by the probation service in response to a note prepared by Miss Fiona Dixon. I have also had regard to the cases of Vowles, 2015 EWCA Crim 45, Edwards, 2018 EWCA Crim 595, Cleland, 2020 EWCA Crim 906, Nelson, 2020 EWCA Crim 1615, and Walker, 2023 EWCA Crim 548. I am satisfied that on the defendant's anticipated release from custody, the particular circumstances of the case and its gravity are such that his state of mental health and the arrangements to monitor him are likely to receive the most careful attention. Of course, there can never be absolute certainty, but I am as confident as I can be that this is the case here, and I am reinforced in that belief by the opinion of Professor Blackwood. The defendant is as candid as he is able to be about his psychotic disorder and its symptoms. Treatment will be still further established by the time of his transfer to custody, and there is every reason to suppose that he will continue to be compliant with it. Conditions can be attached to any grant of a parole licence. It is likely that any community monitoring process would involve multi-agency public protection arrangements, as Professor Blackwood explained. I am satisfied that proper public protection can and will be achieved in this particular case by the sentence I shall pass. I turn now to the custodial part of the sentence. It is accepted by the defence that the defendant does pose a future risk of the kind that would justify an extended sentence on count 3 and the imposition of a further licence period pursuant to sections 279 and 280 of the Sentencing Act 2020. That concession is rightly made. No pre-sentence report is necessary for me to come to this conclusion. At its simplest, the defendant harboured homicidal thoughts which he acted upon before he became psychotic. There is a significant risk to members of the public of serious harm occasioned by the commission by the defendant of further specified offences. So far as the offence in count 1 is concerned, there are no specific sentencing guidelines. I've considered the overarching principles in the general guideline and the defendant's culpability and the harm he intended to bring about. It is accepted that the defendant's intention was not merely to harm or alarm the sovereign, but was to kill her. In those circumstances, the offence is the most serious of its kind. After a trial, if mental disorder were not an issue, any allowance for the mitigating features of the defendant's age, remorse, and the absence of any previous convictions would be extremely limited, because the fact of his intention to kill makes the offence as serious as it could be. The allowance from the maximum sentence could not be any more than 4 months for the mitigating factors I have indicated. I've taken account of letters written about the defendant and of his letter to me. I then reduced the figure of 6 years and 8 months to 5 years and 6 months on account of mental disorder. I then reduced the figure of 5 years and 6 months by 1/3 on account of the plea of guilty. That is because the plea was indicated at the first reasonable opportunity, shortly after it was confirmed, towards the end of 2022, that the defendant was fit to plead. That results in a sentence of 44 months imprisonment on count 1. There are sentencing guidelines for the offence of having an offended.
Okay, all right, so you are watching and listening there to the sentencing of 21-year-old Jaswant Singh Chail, who has pleaded guilty under the Treason Act. He was attempting to kill Queen Elizabeth II on Christmas Day 2021 with a crossbow when he was just 19 years old. He's now 21. He's also pleaded guilty to making threats to kill and being in possession of an offensive weapon. What we are hearing now is how the judge will sentence him. Clearly, mental health is a mitigating factor, or certainly a consideration, I should say, in this case. What we've heard so far is that the judge says that a hospital order is not the most suitable way of dealing with the case, and that Chail will receive a prison sentence. But in the short term, from what we're hearing there, it's most likely that Chail will remain in Broadmoor for the foreseeable future until he is well enough to see out a custodial sentence. He, of course, has previously had mental issues. We were hearing about how he was psychotic. There was some disagreement with 3 different mental health experts as to the extent of his mental illness. Some aspects to this include him believing that he was going to avenge a massacre in India by killing the Queen, that he had an AI, that's an artificial intelligence girlfriend, he believed, and he believed that she was real and not actually loving him because of its programming. He also was a bit of a Star Wars fanatic, to say the least, and dressed as a Sith Lord, wearing an iron mask made at a forge when he was carrying his loaded crossbow, and he was seeking infamy and some kind of personal legacy by doing this. The discussions there are centering around exactly how much mitigation will be given for his mental health, and I think at some point we may be able to go back to the Old Bailey so we can hear the judge continue to pass that sentencing. But just to remind you of where we are at the moment, Chail must receive a prison sentence but will stay in hospital for now. Back to the Old Bailey.
From mental disorder, this offence would fall into Category A, higher culpability. There was significant planning, and the defendant had a visible weapon in the video. It is Category 1, harm, because he caused very serious distress to some of those who saw it. His sister said that it reminded her of a terrorist video and that it was really shocking. Mr. Powell, a friend, said that the video made him feel terrified. It is plain that the defendant wanted it shared as widely as possible, including with news media. He had referred in his journal to a need for being known. The film would be extremely disturbing to anyone who saw it. Category 1A offence has a starting point of 4 years custody and a range of 2 to 7 years custody. The prosecution have submitted that the uniquely serious nature of this offending places it at the top of or beyond the top of the sentencing range in the guideline. I agree. The overall context of the offending cannot be ignored. He sought to publicise his intention to kill the sovereign when he was in the process of trying to put that intention into effect. Take a figure of 8 years custody after allowing for age, remorse and the absence of previous convictions, which I then reduced to 80 months on account of mental disorder, before allowing credit of 1/3 for the plea of guilty. That would result in a sentence of 53 months custody for making threats to kill, again before making any allowance for totality. So finally, I have to decide what the effective overall sentence should be. There are 3 separate offences here which involve different criminal conduct. I have to ensure that the total sentence is just and proportionate, and that there is effective punishment for separate offences, whilst acknowledging, as I do, that they were all part of one overall plan. A just and proportionate sentence is unlikely to be achieved simply by adding up the separate sentences for each offence. It would not be achieved in this case, and I must therefore make an allowance for what is called totality. I shall do that by reducing what would otherwise be the appropriate sentences for the offences in counts 2 and 3. Again, this requires an exercise of judgment by me. The sentences will run consecutively to each other, and they will take effect one after the other in the order that I pronounce them. The defendant must pay the statutory surcharge. The defendant will remain in hospital pursuant to the order I make under Section 45A of the Mental Health Act 1983 until he is considered well enough to be discharged to custody, up until 1/2 of the period of the sentences on counts 1 and 2 has expired. If well enough, he would be transferred to custody to serve any period which remained of 1/2 of the sentences on counts 1 and 2. Then the sentence on count 3 will take effect. If he is in custody when it begins to run, because treatment has concluded, after 2/3 of that sentence, the defendant could be released on licence, but only if the parole board considered it safe to do so. There will be an additional licence period which is necessary to protect the public. If the defendant breaches the terms of any licence or commits a further offence during its currency, he is liable to be returned to custody. Mr. Chail, on count 1, the sentence is one of 44 months imprisonment. On count 2, the sentence is one of 16 months imprisonment. On count 3, the sentence is one of 48 months imprisonment with an extended licence period of 5 years. The total sentences amount to 9 years custody with a further licence period of 5 years. The defendant may go down.
OK, so the sentencing there has now finished. In the case of Jaswant Singh Chail, the overall verdict on the sentencing there was that he will be sentenced to a total of 9 years with an extended licence period of 5 years. Count 1, of course, which was in relation to treason, has been coming in at 44 months. And then there were count 2 and 3 of possession of offensive weapon and threats to kill, 16 months and 48 months, respectively. He will begin that sentence in Broadmoor in a secure mental facility, and then as and when he is deemed fit to go into main custody at a prison, he will then go there and serve out the remainder of his sentence. We heard a lot there about the circumstances that led up to this particular situation. Whilst it was acknowledged that the man involved had significant mental health problems, it was also acknowledged that he, according to the judge, had violent tendencies and threats to kill before he actually developed psychosis. It was difficult, of course, to pinpoint exactly when he developed psychosis. I believe we can go now to Cameron Walker, who is our royal correspondent, who's been at the Old Bailey for us. Cameron, yes, a very unusual case which has now concluded with an overall sentence of 9 years, with 5 years on licence for a man who attempted to kill the Queen with a crossbow on Christmas Day a couple of years ago.
Yeah, it's incredibly rare for a case such as this. The last time was in 1981. Jaswant Singh Chail, as you said, has just been sentenced to 9 years in custody with a further 5 years on licence. The judge was essentially weighing up there whether or not mental health played a factor in this case, and whether or not a custodial sentence, a prison sentence, or indeed a hospital order was most appropriate. And what the judge concluded was that it is essentially going to be a mixture of the two. He accepted that on Christmas Day 2021, when he carried out these offences, he was in a state of psychosis, as per some of the mental health experts had given evidence in court. That's what they said. But he did say that there was some premeditated planning when Chail was not in a state of psychosis. So what the judge has concluded is that the three separate offences, the sentences being given to those three separate offences will run consecutively. That means one after the other. So 44 months in custody for count 1, that is the Treason Act 1842, intent to injure or alarm the sovereign. 16 months for count 2, that's a possession of an offensive weapon. And 48 months for count 3, that is with a threat to kill the Queen, and with an extended licence of 5 years. So the judge has ordered Chail to remain at Broadmoor Psychiatric Hospital until he is well enough to serve that custodial sentence. Now, this is a summary of Chail's crimes and why he has been sentenced to 9 years in prison.
The moment a self-styled assassin was arrested in the grounds of Windsor Castle, carrying a powerful crossbow capable of firing bolts with lethal force. His target, Queen Elizabeth II. Jaswant Singh Chail was captured on CCTV wandering Windsor town centre before carrying out his crimes. On Christmas morning 2021, he climbed the castle's outer fence using a nylon rope ladder. Chail spent 2 hours inside the grounds close to the late Queen's private residence, where she and members of her family were spending the festive day. Eventually challenged by police, Chail told officers, "I am here to kill the Queen."
He was a dangerous individual, intent on doing harm to Her late Majesty the Queen. And if it hadn't been, as I say, for the officers on the day, this could have been a very different outcome. But the officers are there for that reason, to protect the royal family and others that warrant that protection.
Hours earlier, wearing dark clothes and a metal mask, the Star Wars fanatic WhatsApped a video to family and friends, apologising for what he was about to do. When he was arrested, police found a note written by Chail. Should he be killed by police during the assassination attempt, he asked, "Please don't remove my clothes, shoes, gloves, mask, etc. I don't want a post-mortem. I don't want to be embalmed." He then apologised for his actions. Chail said he was seeking revenge for the Amritsar massacre in 1919, when British troops opened fire on thousands of Indians. In a journal, he wrote that if the Queen was unobtainable, he suggested Prince Charles, now King, would be a suitable figurehead for revenge. Charged with treason, making a threat to kill Her late Majesty, and having a loaded crossbow in a public place, the young man from Southampton was assessed at Broadmoor Psychiatric Hospital, which found he did not exhibit extremism. He pleaded guilty to all charges. During hearings at the Old Bailey, The court heard Chail had applied for the Army, a special police force, Royal Marines and the Royal Navy in a bid to get close to the royal family. It also heard he was encouraged and bolstered to do what he did by an artificial intelligence, virtual girlfriend who he'd exchanged more than 5,000 sexual messages with. Chail's barrister, Nadia Chabat, said he apologised to the royal family and the king in a letter to the court where he expressed distress and sadness about the impact of his actions. His treating psychiatrist, Dr. Christian Brown, recommended a hospital order, but Professor Nigel Blackwood for the prosecution said the attack was carefully planned and Chail was well aware it was wrong. The 21-year-old becomes the first person to be sentenced under the Treason Act of 1842 in more than 40 years. Cameron Walker, GB News.
Well, Chail's mother, father and twin sister were in court to hear Jaswant Singh Chail's sentencing. The judges ordered him to stay at Broadmoor Psychiatric Hospital to receive further treatment until he is well enough to be transferred to prison for his 9-year sentence, plus a further 5 years on licence.
Cameron Walker, thank you very much, our royal correspondent outside the Old Bailey for the sentencing there. Lots to unpack about that particular case. A vast swathe of very unusual different elements to it, and I think not least as well the role that AI and artificial intelligence may well have played. We'll be discussing that a little bit later on. But